Welcome to this very special edition of the KAJ Masterclass Live, the show which ensures that you profit from your time spent here with experts, either through their industry insights, information, or simply learning from them. And today we have Austin Bonderer. He is a seasoned patent attorney with over 2 decades of experience. His portfolio boasts over 690 issued US patents, a former US patent examiner, and former head of US nanotechnology prosecution for a Forbes World 100 company. Welcome to the show, Austin.
Thank you very much for having me.
You are welcome. Welcome to the show. Welcome to India in this online form, Austin. And I'm sure not just in India, but a lot of people across the globe will benefit from what we are going to talk right now. We'll learn from you about mastering the US patent process. We'll learn all about that. But before that, let's learn a bit more about you, Austin, about your background, about your journey, so that the audience knows who they are listening to.
Well, basically, it's just kind of one of those things. I started off, studying engineering in college, and then coming out, I had 2 job opportunities. But I'd always been drawn to patents because when I was actually my senior thesis was developing a wireless smoke detection system well before that they had one on the market. In fact, I actually believe I beat these people to coming up with the invention. But at the time I was a college student, didn't have the money, could not fund my patent. Thus, it just sat on the shelf. And this is a story that I hear from many clients. So after that, after I graduated, I got a job at the patent office, became a patent examiner, went to law school at night, then came out and been practicing law ever since.
Absolutely, Austin. So, in terms of patent, U.S. patent law, who should worry about this? Is it that I'm sitting here and making something and I think it is the biggest invention of mankind and I should get it patented? How does that work? What's an invention in that sense that needs to be patented?
Well, that is definitely up to, the client. I always tell people when they first call my office, hey, you don't need a patent to make money, because you can look around your office, your home, and you can see tons of things that are made that are not patented. What a patent helps do, what it does is help you protect your research and development if you do happen to have a novel idea, so that you can build your business with some more protection. Also, one of the functions of a patent is that if you believe it's a business model where you're going to need investment, patents are something that, investors are really much looking for, because it protects their investment even a little more. Granted, all this stuff is speculative. We know it. We've seen people go out there with what we thought to be great ideas, and it might not make it in the marketplace. It might, but it does make it a little easier if you have a patent protecting your idea.
Absolutely, protecting an idea. So how do I know, that, okay, my invention, my idea that I have created is patentable? How do I know? Suppose one is a person in the US, he or she makes something, and one is another person sitting in another corner of the world, maybe say in India. How should they look at this whole patent thing in the US?
Well, basically the reason why that sounded like 2 questions. How would you know? The best way to know if something's patentable is to get a prior art search conducted and examined. Now, understand that no search is 100%. And even if the search is great and they don't find something, it doesn't mean that the patent examiners are going to agree with our assessment. So even if you have a good, clean patent search, there's still a risk in going and obtaining a patent. Now, I'm sorry, what was the second part of the question?
Right. One is the person who is invented something in the US, and suppose someone in India. How would they look at it? How should they look at it?
So, basically, I guess one of the selling points of the US, you almost always want to get a patent in your home country. And a lot of countries require you to get a foreign filing license before you file somewhere else. I think the attractive part of the United States is that it's one patent that covers what is the United States and consumerism? It's one of the highest, bang for your buck when it comes to patenting a product because the United States market is so large. And then the other part where you should look to patent your invention, and this is what I tell my US clients, is where are you going to have this made, or where would your competitors have this made? And you know that there are certain manufacturing centers in the world, India being one of them, is that if you find that that's one of your locations where your product's being made or will be made, you should probably get a patent in that country as well, because I always say, like, someone in Germany might be able to make and use and sell your product in Germany, but you're still going to be able to bring it to Germany cheaper than that person could make and sell it there. So you'll win in the marketplace, even though you don't have a patent necessarily in the EU.
Okay, so what is the process? Suppose if I make something again in India and I want to patent in the US, is there a process that I need to be prepared? It's like a college admission that I'm going to prepare. Do I need to prepare for it, or do I need to just come to you and tell, "Hey, Austin, I need this patent for this particular thing. Can you help me?"
Well, that's the part. Yeah, you bring me your idea, and then basically, some people ask me, "What do you really do for a living?" And I'm like, I basically write term papers for other people, and then argue those term papers before the patent office. So basically, what you would need to do is provide a patent attorney just enough so they can understand the invention, so they can write it, a specification, produce you some drawings, and then I call it's teamwork. So basically, I will write something up and send it to you, and then you can say, "Hey, I need more disclosure on this front. I need this wasn't exactly my idea," because I always say, let's put everything in that we could possibly think of. Another thing I always tell clients is, inventors tend to be very specific, very much about their exact invention. Like, it has to be this way. This is how it's going to be made. And what a good patent attorney will do, and this is why I always tell my clients, is take a step back, because we all know that people are willing to spend less money for an inferior product, right? So you want to take a step back and come up with ideas of what you would do to try to get around your own product. And you want to put that into the patent application as well, because what you really want to do is box people out. Basically, you want to dominate the space that your invention is so that no one can come close. And the best way of doing that is describing a bunch of different embodiments that might not be your preferred embodiment, the way that you want to make it and what you want to sell. But basically, you've made enough space around you that it's very hard for people to come up and invade your space.
Right. What is the process like for a simple person? What is the process like? Okay, I've made something, and if I can afford, obviously I will afford an attorney. But if I don't, how does an individual wade through this whole process?
Well, that's it's I can just tell you the process, but I've seen some at the end of the day, it's a legal document. It's almost like contracts. You've seen what happens when some people write their own contracts versus going to an attorney, but I'll explain the process anyway. So basically, the first thing they should do is do their own prior art search. They should go to Google Patents or their home, patent office, and they all have search functions where you can go on there and look for, things that may prevent you from getting a patent. Now, understand the way patents work. There's typically two bars. The first bar is what you've invented is not out there. And then that what you've invented is not obvious in view of something else. So basically, what the patent office is allowed to do is take element A from one disclosure, one piece of prior art, element B from a second piece of prior art, and put them together and say it would have been obvious to put those together to arrive at your invention to prevent you from getting a patent. Now, I'm sorry if I got a little off track. So the process is basically the prior art search. You go out, you look. If you didn't find anything, then you feel a little more comfortable moving forward to preparing a patent application. So what you do is you prepare the patent application, you submit it to the patent office, and at least here in the US, it takes typically 2 to 3 years before they even look at it. So that's when you have that patent pending phase. So what I tell people is once we file it, that's when you go out and try to make the money off, monetize your idea. Because at the end of the day, it doesn't matter if you get the patent or not. If it's a good idea and it's going to sell in the market, you should still try to make money off your idea, even if it's not patent worthy. So once it's filed, go out there and try to make money off it. So 2 to 3 years later, most likely they're going to send you a rejection. I always joke that it should be called the rejection office, not the patent office, right? So, and they send you the rejection, and that's fine. It's just part of the process. Being an examiner there, I can tell you there's pressure on them to at least send out something one time. So then basically you have to file a response. You probably have to edit your claims. And, it's kind of game theory at that point in your response, because it depends upon what art does the examiner cite, what do you want to do? How far do you want to go? Do you want to argue with them the whole time? Or do you just want to negotiate and come to a settlement, basically, where you can get your patent and everyone's happy and they move away? Because at the end of the day, the examiner wants you to narrow your claims, but you want the broadest claims, because that's where the value is.
Right. It's interesting that the first thing is you should be ready for that rejection. Why do they do that? Do they want to look like that they are busy, very intelligent examiner, and then you should show intelligence beyond that? Or maybe they are testing your seriousness about your innovation?
No, it's more, I would go that, I would say very seldomly have I had a frivolous, rejection. But there are times, and I used to work at the patent office, so I felt this pressure too. And if you went to your boss and you say, because it's hard to prove a negative, because your job is to go out there and find something. And depending on how well you looked, you may not have found anything, but you may be looking in the wrong spot. So if you go out there and you find nothing, first thing your boss is going to say is go find something else, because they want to make sure you're doing your work. So basically you need to go, the pressure is to go out and find some prior art and then file, write a rejection and send it out. So, and then the idea is that in the first rejection, they're supposed to find the best art they can find. And hopefully you have a universe of prior art that you're working in when dealing with the patent examiner. That way you can make your amendments and hopefully get past that stage to an allowance.
Right. Just Austin, you have been a US patent, examiner. Why do they take 2 to 3 years for even a rejection? What do they do in this, in this whole meanwhile? What do they exactly do? I thought in the US, people, all those offices and all are very, very efficient. Why would they take so much of time?
Well, it's just a personnel issue. I mean, it's just the amount of patent applications that come in and a limited amount of people that are able to do it. And so it's considered one of the higher end government jobs in the US for the federal government. I think it has the highest civilian pay scale. And the reason being is that it's a very difficult job, has a high burnout rate. We used to joke that it's probably the most conducive job to work from home, because basically you got into an office, you shut the door, you didn't open it for 8 hours, and then you left, because it's nothing but a research job. And it's, as soon as you finish one, you just have another one that sits right on your desk, and it's time to start again. So it's just the time that it takes, and it's the backlog given the amount of employees that they have.
Right.
Yeah. But what I will say is that it used to be worse. They have made a very concerted effort to lower the pendency of the first office action.
Right, right.
Right.
Do you think this Department of Government Efficiency will be looking at this particular office also to ask them to be more efficient, bring in more people, or reduce people?
I have no idea. I could imagine them trying to insert AI into the process. And, the patent office has tried that as well. So they'll do like a pre-automated search for prior art and give that to an examiner. And still the examiner needs to go out and search themselves. Um, the patent office is probably the way it works there for a patent examiner is you have X amount of work you got to get done every 2 weeks, and then every year or every quarter, and then every year. So as far as government jobs go, it's probably the most accountable and easiest to fire people if they're not meeting that standard. So it's not, I don't know how efficient, or, if you could make some more efficiencies by pushing up the amount of work that some people have to do. But I know that some people are, truly, bust their tail and work very hard as a patent examiner to meet their goals. Of course, it's just like any other business. Some people probably skirt a little lower, get by with a little less, and you have your people that excel. So I actually really enjoyed the job.
Absolutely, absolutely. I'm sure you did. But what about the people? If they have to wait for 2, 3 years for their first letter from the patent office, do you think someone can, steal their invention? Something can go out, and by that time their edge is over. Someone else files something else.
Well, I mean, the thing is, you still have the priority date, so you will win. So it's all about who filed first. And that's pretty much the system with, I believe, in almost every country now, is that the first to file to a patent office always wins. Now, the United States actually has an interesting kind of aspect of patent law that most countries don't have. Most countries require you to file before any public disclosure or offer for sale. But the United States is a very lenient, that it gives you, a year from your first public disclosure or your first offer for sale to file your patent application. Now, that's what can kind of get you in trouble, because say you're out there, you have your idea, and someone kind of sees it, they file a patent application before you do, and then they might actually get priority over you unless you can prove they actually figured their invention out from your disclosure.
Absolutely. Is there a way to get your patent done at a quicker pace? Maybe has it happened that you get your patent in the next 6 months, and also, does it happen like that?
Okay, 6 months, it might be a little tight, but the best you can do is that they have these programs where always with a fee, right? You can pay extra money, and they will give you your first office action, typically your rejection, within a calendar year. I'm sorry, not calendar year, 12 months. There's also a thing that, say one of your inventors is over, I think, 55 years old, they will automatically, you can petition and they will put it where it will be examined within a year as well. And then I believe there's a new program that if it's your first patent application, they will review it within a year as well. So there are some ways, but most patent applications, 2 to 3 years.
Can an attorney find a way out to some open doors through another process, or they have to go just through the same process?
Exact same process. Yeah. So
right.
Even though I know people at the patent office, there's no pulling strings, because I honestly, I have been practicing outside the patent office since 2005, and not a single one of my patent applications have ever gone in front of someone I used to work with. Because you're looking at, I don't know how many patent examiners are now, but probably like 9,000. So it's a big number.
9,000, and they
I
sit
think
in the
it's
same
somewhere
building.
like that. It could be 7 to 9,000. It's a lot. So I mean, it's your and when you're filing a patent application, you're kind of throwing at a dartboard because even within a specialty, you still have, you know, 20 people inside that specialty who do the patent or who are the patent examiners.
Right. With AI coming in, now so many things will be around artificial intelligence. Can those things be patented? Are those patentable, Austin? Or is it more about inventions of different kind?
At the moment, what they have decided is that, you know, the way the U.S. patent law is written, a person must be an inventor. So the AI can't be an inventor. So that's what they're dealing with now. Will that change? I don't know. It's not like one of these things where I created the AI created the invention, hence it's my invention. They literally say if the AI created it, you cannot file for a patent application for it at this time. But obviously, you know, law moves quickly, actually slowly, excuse me. Technology moves fast, much faster than the law does. So, yeah. But there is
Absolutely.
an interesting thing about AI I would like to say, just warn people about. So, a big thing that we're always worried about as patent attorneys in the patent system is public disclosure. So, if you're working on your invention and you throw it into a publicly accessible AI system, there's arguments that that is actually public disclosure because we all know what AI does. It absorbs everything we tell it, catalogs it, and keeps it, and then disperses it out as needed. So using AI to search your invention may be a you know precarious thing to do. You know, putting your whole invention in there and saying, "Hey, write my patent application." That might be a precarious thing to do because you have literally disclosed it to the most knowledgeable, I guess, entity in the world. So you might be dealing with a public disclosure issue.
Right. That reminds me of one thing, Austin, is that people may not put out their invention into AI tools, but they may try to look at the knowledge gap. And how do they? Obviously, also the internet is so much attached to AI now. AI is also, Chat GPT has got this whole search system. Even DeepSeek, I guess, can do it. So I want to understand, how do you do even your research on the internet? Or do you only have to go to one database? Means then research itself can also mean that it's going into artificial intelligence is somewhere through that AI search, and then through the search it is also pulling it to educate itself. I mean, that's a very difficult thing for anyone to do their research.
Correct. So I don't do my own patent searches. It was a skill that I had a long time ago. You're better off shipping it off to a search firm who has, you know, the uh, the skill. They basically have a finely honed skill that they do all the time. And the reason why I would be careful about using, like you said, even AI to search. And I get what you're saying about AI being part of the internet, but most search firms use patent databases. And it's also my understanding that, you know, if say you're a big firm or you are, you know, willing to pay for it, I think you can now get closed off AI systems. So you might be able to use those kind of tools to help you. And maybe those search firms will do that. But the big issue is that you want to keep the information that you're putting in there in a lockbox so as it doesn't then become part of the AI model.
Absolutely. That's a lot of things to know about all these things, Austin. And I'm sure a lot of people would want to understand this whole process because it's a very difficult. What about people? How would you search for inventions outside your country? Means then also you need to come to the search process. Where will you escape? It's like you can't escape from your own phone. In the same way, any research cannot be escaped from anywhere from this internet.
Well, what you can use, I mean, if you want to search the international databases, there's ways to do it. But like Google Patents is very good. It searches patents from all over. You can restrict it to just US patents, but they will do the major countries, that they're able to do. Um, I think part of the problem is, if you get your minor countries, the databases aren't hooked up. But the searchers will generally limit themselves not just to your own country, but generally the patent database. They're really just looking at old patent applications and patents. And because that's what the examiners do, the examiners rarely move out of their patent database. I remember when I was there, it was paper. We'd go to these files, they're called shoes, and we'd pull them out, and that's all we looked at, paper patents. And then they obviously, turned it into computers back in 2000, I guess.
Right. So in a nutshell, Austin, as a inventor, a potential inventor, what are the do's and don'ts in a very simple way that people can always remember before even filing for it?
Well, say that you really wanted to do your own search. And one of the things I would suggest, because using terms is good, you want to use terms, but you also want to use classification searches. So when you do a classification search, you find out a lot of times professionally, you can actually call up the patent office and they can put you in touch with examiners and they'll tell you which classes your idea might fall in. So what you do with those is that you actually go through every single piece of prior art, patent prior art, not, web-based, and you look at every image. Now, say you're dealing with, methods and these kind of things, that makes it a little more difficult because that's very word-based. And it's, how it is with words. Some people can call the same thing, 5 different words. But when you're dealing with structures, that's why you look at the figures, and that way you can actually see it. The words don't matter. The words can help narrow down your search and help you with your search, but you also want to be very generic in your search terms. You might want to say that you have a screw. You might want to say screw or fastener, because patent attorneys, their big job is to make things seem broader than they are. And when you use a very specific terminology like screw, you've now excluded nails, tacks, or any other kind of attachment means. But if you use the term fastener, it includes all of those. So, but you're relying on a patent attorney from the past to have done that. So that's why you got to use generic terms, specific terms, so basically when you're looking for something, think of all the different words that could be used for it and put those in the search queries.
Absolutely. There is, and during the process, once I submit my application, should I forget it? Should I wait for the rejection letter? Or should I need to keep on pestering the patent office? Please do it fast.
No, that won't work. You call them, they would just ignore you, or they say, "I'm sorry, I can't do this for you." In fact, the patent office now has a automated letter that, when I have a client who's like, "When's my, patent application going to be looked at?" And I can go on there, click on it. It's automated message, and it gives an estimate. It could be 22 months from now or something like that. And pestering them won't do anything. So I always say, leave that patent stuff alone until you have to deal with it. What you should be dealing with right now is trying to make money off your invention. Because at the end of the day, that's the whole point, right? Make money.
Absolutely, make money. So lots of things to understand about these things, and at the end of it, I seriously see the importance of getting an attorney like you to get this whole patent thing done. So for those people who would want to connect with you, learn more about you, more from you, about the process, want to get their patents, what's the best way for them to connect with you, Austin?
The best way would be through my website. or just search Austin Bonderer, patent attorney. I am the only patent attorney named Austin Bonderer, or Bonderer at all. So that's the nice part of it, of having a unique name. But that would be easiest.
Wonderful. With this, it's a wrap on this very special edition of the KAJ Masterclass Live. Thank you so much indeed for joining us.
Thank you for having me.